Hi, it's me, Bob Jokel with Hunt Real Estate. I've been selling real estate in Central New York for over 20 years. Welcome back to my YouTube channel devoted to helping the general public understand everything that goes into buying and selling homes. Today we're going to talk about the importance of hiring a good real estate attorney whenever you are buying or selling a home. My guest today is Ann McGrath. Ann is an excellent local attorney with extensive experience in real estate law. Hey Ann, thank you for joining me today.
Thank you for having me.
Ann represents buyers, sellers, and sometimes mortgage lenders, and she comes highly recommended. I can tell you from personal experience that Ann has done a great job for many of my clients. And so anyway, in most states, home sales are closed in escrow by title companies. But in New York, we close with attorneys. So having an attorney that represents you is extremely important. And when you represent a buyer or a seller, what are your responsibilities to your clients?
My primary responsibility when I represent a seller is to ensure that they have the right amount of money when they leave the table. And for buyers, their primary focus is to ensure that all the contract terms are met to their satisfaction. So that would include things like making sure that any personal property that they were supposed to get is left with the house, or anything that was supposed to be removed is taken away. Mm-hmm. And for sellers, sometimes there are adjustments that need to be made for closings that are a little different, and I am there to make sure that the math works for them.
Okay, so can you explain the difference in your process depending upon who you're representing? For
sellers, I review the contract, make sure that they understand that the contract closing date is on or about, ensure that they're not going to be left homeless if we don't close by the date that's in the contract, verify whether or not they actually have to sell in order to buy their next home if they are buying. For buyers, it's to ensure that they don't give notice to their landlord if they're moving out of a rental property prior to being able to close, helping them through the loan process by hand-holding, not so much to answer the questions about the loan, but to help them recognize that there are things they need to do as part of that loan process, like not spend any money, not do any new charges, making sure that they keep track of any documentation that they hand over so that it's in a nice neat little pile in case they need to access it again. Getting to the closing table really revolves around getting the buyers cleared to close by their mortgage lender.
Mm-hmm. Yeah, one of the things that makes us a little bit different in this part of the state is that attorneys really don't write the purchase contracts. Downstate they do, the agents just write an offer sheet and the attorneys write the contracts. Here we have a fill-in-the-blank contract. It's basically a boilerplate that was approved by a group of local real estate attorneys. And so when the agents write the contract and everyone completes it, the buyers and sellers complete it, the seller's attorney and the buyer's attorney have 3 days to review it and approve or disapprove.
Correct. And the general process that I work through is, unless there's something in the contract that's written in that strikes me as being completely out of left field, my general process is to approve as long as my clients understand that this binds them and they're going forward and they're now getting a home or selling their home. It is a rare occurrence that I disapprove of the contract out of hand. I just have learned that the real estate agents that I work with are very experienced and know not to try to write any legalese that is going to be objectionable to another attorney.
Okay. Yeah, it's important as for real estate agents, we understand that we don't practice law, we sell real estate. So we're prohibited from going over a certain line when it comes to writing things into a contract. Those are items that are best handled by attorneys. And our clients need to also understand that their attorneys really don't negotiate the contract. The contract is negotiated by the agents. It's up to the attorney to approve the contract, make sure that their client is protected.
Exactly. There are certain provisions that do get written up, things about, let's say, a pool inspection, or things that aren't part of the regular processing of the boilerplate fill-in-the-blank contract, that we attorneys have the opportunity to review, go over with our clients, and then yay or nay, whether that is approvable to us or problematic.
Okay. So previously I recorded a video with Rick Zimmer from Network Title explaining what an abstract of title is. Can you go over what you look for when you're reviewing an abstract?
So an abstract, for those of you who haven't watched the other video, is a history of the ownership of the property. It pertains specifically to the parcel in question, and in Onondaga County has to go back to at least 1945. In many of the surrounding counties, it has to be a 40-year abstract. So at this point, we're looking at 1981 as being the starting point, which is 40-year difference between Onondaga County and those other counties. And that the rationale for that is post-World War II, a lot of developments were created. And those developments have easements that came along with them, or restrictive covenants that go along with them. And if you don't go back to at least 1945 in doing an abstract, you miss those. And those are important because they pertain to the particular property. So that history of the ownership shows who's owned the property, who has sold the property, who has died while owning the property, mortgages that might have been granted as part of that ownership. And when I represent the buyer, my job is to ensure that everybody's interests from the past have been disposed of. And when I represent a seller, my job is to make sure that there isn't anything since they acquired title that is problematic, such as a judgment or lien or a mortgage. And if there are any of those documents that are filed against the property or against the people that own the property, that those are cleared before we close.
Okay, so when approaching potential issues, it depends on who you represent.
Correct. I don't want to raise a red flag if I don't have to, but my job representing the seller, particularly, I have a problem right now where there was 3 open mortgages, and the second mortgage was clearly intended to be paid off by the new third mortgage. And it, as a matter of fact, was, and it was just a problem. The abstract company just missed it and didn't mark it off. And so that's cleared up, and so we can close.
Okay, excellent. Now, just want to touch base on, when a buyer is purchasing a home that might be in foreclosure. Short sales we're really not seeing right now because of the pandemic, and with home sales rising as quickly as they are, it looks like short sales may become a thing of the past.
To God's ears.
Yeah, to some extent, because there's nothing short about a short sale. But if a property's in foreclosure and you're representing a buyer, is there any special things that you look out for when it comes to protecting the buyers?
Yes, particularly representing buyers, the foreclosure requires notice. And as long as those notices were properly given, filed documentation to that effect will be part of the court record that goes with the actual foreclosure. So what a foreclosure is the bank taking back the property. And the bank then has the authority, once they own the property through the proper foreclosure process, to then sell that property to try to make up the difference between what they were owed at the time of the foreclosure and what they're selling it for. That's called a deficiency judgment, and they can then go after the seller for that difference, after the process is over. It has nothing to do with the buyer. So my job as the buyer's attorney is to ensure that those notices were properly given and that any of the intervening judgment creditors or lien holders were cut off so that there's no further ability to claim against the property by anybody other than the new buyers.
Okay, because the bank holds the mortgage, so they're first in line.
Correct. A mortgage cuts off the subsequent lien holders because New York is what we call a race state. We race to the courthouse to get our documents filed. And upon the filing of that mortgage, that cuts off anybody that comes afterwards because everybody's on notice that this mortgage exists and is against this property.
So basically on notice, what's happening is the banks are notifying the other
Potential lien holders.
that they need to release their liens because they
don't have the authority to...
they can't execute the lien?
Correct. They can't collect on those liens without looping in the first mortgage lender, who then has the authority to say, no, we'll foreclose.
Okay.
So
Alrighty.
that's how that happens.
So, and again, there's a moratorium on foreclosures right now during the pandemic, but it's not going to last forever.
Correct. And Bob and I have had a conversation in the past about the fact that people who have not been paying on their mortgage for the last several months at least are not going to be able to come up with the lump sum that's going to be required to catch that up. So my best guess is that we'll be seeing a lot of add-ons to the end of a mortgage value so that people aren't forgiven the amount of money they haven't paid. It's just delayed in having the ability to pay it.
Okay. All right. So now the surveys, the land surveys, are also a big part of sale and purchase of property. What do you look for when it comes to surveys, and does it vary depending upon who you represent?
It varies only because of the resolution that I'm going to try to create. So land survey, as I like to tell my clients, is essentially a bird's eye view of the property lines. It is a depiction of the property lines. Drawn on it are any of the outbuildings, structures, fences, easements that might have been granted to particular utilities, things like that. And my job when representing the seller is to make sure that my seller hasn't put up an outbuilding that encroaches on the neighbor that wasn't there when they bought. And if that is the case, then there are processes that I go through to contact the neighbor, get permissive use, or get the neighbor to give me a deed that gives my client that little piece of property that they are encroaching on. On the buyer's side for a survey, my job is to make sure that they are aware of any of the property lines, the location of fences, a shared driveway, anything that might impact their use of the property going forward.
Okay. And how do you approach potential issues? Sometimes fences are a real joy.
So it depends on the town that the property is located in, where the fence should be located. My recommendation usually, if people are going to put up a fence, is put it right on the line, because that way there's no question of your ownership of that piece of property. If you put it within the bounds of the property, offset by 5-10 feet, you're leaving a gap between your property line and that fence that potentially then could be open to somebody claiming that they own up to your fence rather than just up to the property line. So that's problematic, and you can avoid the problem by doing that.
Okay. Now, we used to have closing statements and HUD-1 or HUD forms and all that good. Now we have what's called the CD, which is better known as the closing disclosure. And how important is that?
Well, the closing disclosure is a document that the bank representative, your bank loan officer, the closing department within the bank prepares. At first, to give you an estimate of what your costs are going to be, and then as we get closer to the actual closing date, they fine-tune what your closing costs actually are. The closing disclosure that we rely upon is actually prepared by the bank attorney after they receive the seller's closing statement, which is an enumeration of the items that the money that the seller is expecting to walk away with after adjustments for taxes, and then minus any bills that the seller would like paid prior to closing, or that needs to be paid prior to closing, such as their mortgage. Once the bank attorney has that document in hand, they can then incorporate it into the closing disclosure that the bank rep has already prepared to get to a final number. The closing disclosure also contains information about the loan parameters itself, so that it's a final double check for the buyers to ensure that their interest rate is stated correctly, that they are their mortgage actual monthly payment is on there, which incorporates not only the mortgage payoff amount, but also any escrows that they have to include, taxes, insurance, mortgage insurance, anything like that.
Okay, so you really don't prepare the CD?
I do not.
That's done by the bank's attorney?
By the bank's attorney, correct.
Oh, okay. But you go over it and you make sure all the T's are crossed and the I's are dotted and that the
Correct.
numbers are correct?
Right. So in this area particularly, the bank attorney cuts all the checks from closing, including bank payoffs, and then the proceeds that are remaining from whatever money the buyer is borrowing, and then the difference between what remains and what the seller is expecting is required to be brought to the closing by the buyer in the form of certified funds.
Okay.
Which sometimes comes as a surprise to clients. So I like to stress that. It is a certified check that is required, or you can get the funds wired into either the bank attorney's account or my account, or your attorney's account, and then they can cut an attorney escrow check because that's accepted at closing as a substitute for certified funds.
Okay. And can you take us through a typical closing from both the buyer and seller's perspective?
So the actual closing process from a seller's side is much easier than a buyer. And especially in the time of COVID, most sellers' attorneys are not even going to closings. We send everything in escrow to the buyer or bank attorney and get back the signed document that we need for our client along with their funds the next day. So what I typically do for a seller is prepare the closing documents at the same time as I'm preparing the packet that goes to the buyer's attorney to review. And that includes the deed, the 2 documents that go with the deed when getting filed, and various affidavits that are required for closing, and an authorization that would allow me to prepare or sign documents or do whatever the buyer's attorney requires for closing. Also at that time, when the seller comes in to sign everything, hopefully I've gotten authorization to do the closing so that I can prepare the closing statement so my client knows how much money they're going to walk away with once closing has occurred. From a buyer's perspective, the closing requires attendance at the closing itself so that they can sign the documents required by the bank in order to perfect the bank's interest in the property, their mortgage, and any attendant documents that are required by the bank attorney to meet whatever federal regulations have to be met, or whatever state laws they have to comply with, and to ensure that the buyer gets the deed package so that they actually know that they own this piece of property now. And I basically handhold through that process to ensure that the buyer is comfortable with the documentation that they're signing.
Okay. So title insurance, subject title insurance comes up at closing.
Hopefully prior to closing, because there are disclosures that we're required to do.
Okay.
As part of our representation of a buyer, we are required to give them notice that title insurance is available to them. So I understand what is title insurance is the next question. And it is insurance against the unknowable. So you're required to have homeowner's insurance, which insures against any potential future issues that might arise. Somebody falls on your property, or you have a fire. What title insurance does is it insures against past acts and problems that might have occurred that we have no way of knowing about. Somebody who has a deed that they never recorded against the property, or an heir that comes out of the woods because nobody ever notified them that they had an interest in this property. And so title insurance is a one-time premium that you pay at the time of closing. It protects your interest in the property. As we used to say, the Land Title Association, it insures your little piece of the planet. And it makes your ownership a protected right.
Okay. All right. So what is your best advice to both buyers and sellers regarding a real estate transaction?
My best advice is to find an attorney that fits you, that makes you comfortable, that you feel answers your questions without any nonsense or puffing smoke, as I like to say. Somebody that you feel comfortable going to with questions that might strike you as completely crazy. So as I like to tell my clients, I know what I know and you don't. So what I can give you for a comfort level is between us. Our responsibilities as attorneys are to ensure that your rights are protected. So anything that you tell us is protected by attorney-client privilege. Generally speaking, I share information with the realtors so that they're in that same loop, because their interest is to also protect you, because they're looking for you to give them future business, and they don't want to have you be angry or upset at the time of the closing for any reason. So that's my job.
Okay. All right. And thanks again for appearing in this video and for sharing your expertise with us. I hope that the information we discussed in this video has been helpful. Please like and share this video and subscribe to my YouTube channel so that you can access all of my informational videos. If you have any questions about what we discussed today, feel free to contact me or Ann. We promise to get back to you as soon as possible. And right at the bottom of this video is our contact information, so we have it right there for you. And as always, if you're planning to buy or sell a home, please reach out to me. You can be confident that I'll take good care of you. In the meantime, stay safe and well, and stay tuned for my next video.